If you draft the agreement and there's an ambiguity or an issue with it, it's construed against you, unless the agreement says that it won't be construed against the drafter. Number 5, survival of covenants after a transaction. If you have an agreement that says we're going to do all these things and then we're going to close and we're going to exchange money and property, then all those things go away and you can't enforce them anymore unless you have special language that says that they'll survive the closing. Number 6, if the agreement is silent, you can amend the agreement orally, and if you can amend the agreement orally, then the other side may lie and say that you amended it. So you need a provision that says that this is the whole agreement, nothing oral, that no emails, only thing that applies is this agreement. And it will no prior agreement, and we can't amend this agreement except in writing. Now, when you have an agreement that says that you can't amend it except in writing, is an email writing? What if somebody sends you a 6-page email and in the middle of page 4 it says, and by the way, this is changing, I assume you agree? I've seen that. I haven't written those emails, but it seems like a cool idea. So you want that agreement to say this will not be amended unless we agree in a separate agreement physically signed by us. So you don't get that. Number 7, situs of litigation. You could agree that any lawsuit has to be brought in your county. So if you're going to sign an agreement with a supplier and they're in California and it says that any dispute is in Los Angeles County, you want to change that. Any dispute is in Tampa, is in Hillsborough County. And then the compromise is often that any dispute will be in Dallas, where the parties would meet halfway. Incorporation clause says that anything mentioned in the beginning of the agreement is part of the body of the agreement. And believe it or not, there's a lot of issues when you don't have that properly. Okay, number 9, pre-litigation mediation. Mediation became very popular in the 1980s, and it's a really nice thing. In mediation, parties having a dispute jointly hire a mediator. The mediator is neutral and typically sits with the parties in one room and says, okay, let's all sing Kumbaya, and then you guys go to that room, you guys go to that room, and I'm going to go back and forth. And most disputes are solved at mediation or at least reduced in mediation because the people realize what's going on. And a good mediator can make a lot of progress. So my agreements almost always say that mediation can be required before a lawsuit is filed, before the tempers fester, before the things get worse. Because usually mediation isn't ordered until a few weeks before trial. So I want a pre-trial mediation clause. By the way, the better lawyers and the better negotiators are very civil and polite when a dispute is going to happen. You know, hold your friends close and your enemies closer. Even when the other side is being really jerky, just to be very constant, very straightforward, very friendly, very accommodating. Those lawyers who do that and are class acts get much better results than the lawyers who are jerks and bullies and they scream and yell and they manipulate their clients. So, you know, don't go down that road. You want to take the high road when you're in negotiations, even when the other side is being jerky. I'm working right now with a situation where the other side is very jerky, and I've been very straightforward, and I've been getting help from a litigator but hiding the litigator because I didn't want them to know. Our side doesn't know there's a litigator ready to go. And we had great news this morning. Her lawyer quit. Her lawyer quit. Because her lawyer is more like me. He is a litigator, but he's more like me, so he quit. It's never good to lose your lawyer. And another lawyer who knew him told me, hey, he quit. He refused to be her lawyer. So, you know, my clients were saying, be mean, send her nasty letters, accuse her of this, tell her she did that, and I didn't do any of that. I just continued to be polite, and her lawyer quit. So we have a better chance of solving that. Okay, page 52, time is of the essence. If you don't have a time is of the essence clause, then Southern time applies. You will pay this January 3rd, but there's no time is of the essence clause. It could be a lot later in January that you get paid. So you want a time is of the essence clause. Believe it or not, some agreements don't give you the opportunity to terminate them upon breach because your lawyer forgot to put that in there. It's common with employment agreements. If you do anything bad, I can terminate you, but it's silent on whether you can terminate me if I'm a bad employer. So you want to breach.